Hi there, this is Jonathan Ginsberg. I'm one of the attorneys here at the Bankruptcy Law Network. I practice in Atlanta, Georgia, although I try to write about things that are more general, not specific to Georgia law. But of course, there's a disclaimer before taking anything I say or anything anybody else at the Bankruptcy Law Network writes about or does videos about. You want to check with your local counsel to make sure that the general rules we talk about are applicable in your jurisdiction, because even though bankruptcy is federal, there is a real carve out for local and state rules that can make your results and the impact of your factual pattern very different than this similar kind of pattern might be for somebody in a different state. So just be aware of that and always seek individual counsel for your specific bankruptcy needs. Now, what I want to talk to you about is the question, and it's something that pops up in my practice periodically, usually a couple times a year. What happens if you're in a Chapter 13, a confirmed Chapter 13 plan, and you find yourself going through a divorce? Obviously, it's a problem because the plan that you put forward when you originally filed your case assumed two incomes most likely. It certainly assumed a budget based on a household of a certain size, and now all that's gone. You may have lost income, you may have new expenses, you may have a completely different budget. So as a rule, you can do a couple things. One is, and this is what I try to do, first of all, you can look into asking your lawyer to request that the court give you a 2 or 3 month deferment in plan payments. And a deferment basically means that you don't have to make your plan payment for 2 or 3 months while you get back on your feet. Now, this would not impact your creditors in terms of payments you need to make to them. So, for example, if you have a car lease you're paying directly, you got to keep doing that. Mortgage payment, you got to keep doing that. But as far as the plan itself, many times judges and trustees will give you a couple months to get back on your feet. And again, creditors can file objections and so forth, but most of the time 2 or 3 months is not going to make a big difference, and you'll get yourself a little bit of time to get back on your feet. The second thing you can do in many cases is you can file an amendment to your confirmed plan. And that amendment may be to reduce your monthly plan payment. It may be to reduce the percentage dividend to unsecured creditors. It may reduce the pool of funds available to creditors, and thus the percentage. You can do any number of things, but it would reflect your new reality. I found judges are pretty receptive to this. They want you to stay in bankruptcy if you're making a good faith effort to do so. And as long as you can document these changed realities, in other words, you want to document that you have now more utility bills or more food expenses or more insurance costs or more alimony or child support payments. As long as you can document that with canceled checks, with receipts, judges will be pretty receptive to it. But you will need documentation. You can't simply go in there and say, I've got these new expenses, believe me. So if you document it and your attorney is proactive about it, and you and your attorney go to court before you fall behind, before problems start to happen, there's a pretty good chance you'll be able to stay in your case, get your plan adjusted. Sometimes it means adjusting it up if you have more disposable income, but usually it's just adjusting it down. You'll be able to stay in bankruptcy, and your plan will reflect the new reality of your life so that you can move forward. Again, it's difficult because I know a lot of times when you are in the middle of a divorce, things are kind of fluid for a while, and bankruptcy really thrives on stability. But as long as you can provide documentation, and as long as you can show that you now have a different budget and different income expenses and other financial issues, then there's a pretty good chance the judge will allow you to make that change. So the point here is that if you find yourself in the middle of a divorce, it doesn't mean your case is going to get dismissed or that you're going to be stuck with the payment that's reflective of what your life was like a year and a half ago, but you have to be proactive and be willing to document the need for making a change. So I hope this has been helpful. Hope the Bankruptcy Law Network has been helpful to you. I encourage you to read it and share it and let your friends know about it. Until next time, my name is Jonathan Ginsberg, and I wish you well. Thanks a lot.